Good afternoon and welcome to the BRR Media Legal Brief, looking at the main legal issues affecting corporate Australia. I'm David Bushby and today we're looking at enterprise migration agreements, which are being hotly debated and politicised in an environment where we've just seen Gina Rinehart being awarded the first EMA to bring in some 1,700 foreign workers for her Roy Hill project in WA. Here to discuss how enterprise migration agreements work and how they fit within our 457 skilled migration program and how it addresses the overall chronic shortage for skilled labour in this country is corporate migration specialist Katie Malyon from her own firm, Katie Malyon Associates Lawyers. Welcome, Katie.
Thank you very much, David.
Katie, just to kick us off, we want to look at enterprise migration agreements and firstly, what are they and how do they work?
Enterprise migration agreements, we'll call them EMAs, are an agreement that an enterprise can enter into with the Commonwealth Government, in particular the Department of Immigration. So it's a bipartisan agreement to facilitate the entry of temporary skilled migrants. This arose out of the recommendations by a task force in 2010, resourcing the resource sector. We identified we had a shortfall of 80,000 skilled positions, even with funding into apprentices and programs of about $2 million that the government has set aside there, we'll be short about 44,000. So clearly, if we want these enterprises to improve our bottom line, the Australian economy, we've simply got to get skilled workers in. We just do not have the people, not necessarily the skilled people, but just the people. So the way enterprise agreements will work is the project owner, in this case Gina Rinehart, Roy Hill, negotiates an EMA with the government, and then hanging off that will be a number of template labour agreements for the subcontractors who directly employ the scaffolders, the carpenters, the construction people, etc., during the construction phase of the project. So it's an umbrella agreement setting up formal agreements subsequently with the subcontractors. Well,
we've certainly seen Gina Rinehart being awarded the first, and I understand there's a number of others, say about 14 or so other projects that might be allowed to have one. Is it? So it's just the big end of town, large projects we're talking about here.
Very large projects. We're talking criteria for beginning negotiations with the government, a project that's worth $2 million, employing at least 1,500 people at the peak. So very significant, and certainly Roy Hill talking $9.5 billion dollars, and a workforce in the order of about 8,000. So a very significant, investment, capital investment.
Absolutely. Well, I do also want to talk about how EMAs tie in with our current 457 skilled migration program. How does that relationship work?
Well, everyone coming out pursuant to an enterprise migration agreement will be the holder of a 457 visa. So this one is one of the sponsored employee visas where the employer takes responsibility for bringing people out, employing them on market rates, on conditions which are no less favourable than they would employ Australian workers on. And so at the end of that construction period, the work that they've done here, the employer then has to repatriate them back to their country of origin. So it's been a very successful program, very robust monitoring around the 457 visa program, and that's why I think the task force resourcing the resource sector looked at this as a solution to our very real needs to get some skills here.
I also want to look at an announcement that Prime Minister Julia Gillard made over the weekend in relation to a jobs board, an online jobs board that would be initiated. Do you know how that will work?
Well, yes, to a point. There's a little bit more detail to come. The 457 visa program doesn't require any labour market testing, and the unions have, following the announcement on Friday of the fact that the Roy Hill project is now going to be the first of these enterprise migration agreements, very, very critical about how are we going to ensure that Australian workers come first. And particularly in the context of this week here, we've heard of the closure of the Hastings enterprise, and a number of people there being made redundant or jobs at risk. So, you know, a very real issue. How are we going to ensure that Australians get those jobs first? And so this was the Prime Minister's response. A meeting yesterday in caucus coming up with a number of recommendations about spreading the benefits of the boom so that Australians in fact do get first opportunity to apply for these jobs. So it's my understanding that the mining companies, the enterprises which will be hanging off this enterprise agreement, the subcontractors, will need to place their jobs first on the notice board with Centrelink so that someone going into Ryde Centrelink office, for example, can see positions available in WA for refrigeration mechanics, you know, carpenters, whatever.
Well, as I said at the outset, you know, it has been very politicised, this issue, with, I guess, Gina Reinhardt, and then we've got redundancies in various sectors happening, especially in the eastern seaboard. But I do want to get, I guess, your assessment on the skills shortage that we have in this country, particularly in a time where interstate migration is very low, especially considering the big bucks on offer in WA.
They are big bucks. We've heard of truck drivers earning in excess of, you know, $120,000. But the issue is we have people in the southeast corner and we have jobs up in the northwest corner. How do you get people from the eastern seaboard across there? It's a real problem. We've had in the Sydney Morning Herald this morning, a reporter had gone out to the Ryde Centrelink office, interviewed a number of people there. They don't want to go to WA despite the big bucks. You know, even there was one fellow who was even from WA here in Sydney. People choose to stay with family. They choose for lifestyle reasons to make decisions about where they want to live. It's not just about the big bucks. So it does present a problem for businesses, for enterprises. You know, Roy Hill project, and it's one of many that you know, Australia is looking to pull us out, to continue our development, ensure that our unemployment rate of 4.9 doesn't skyrocket, and it is presenting an issue.
Well, speaking of headlines, I did also see in The Australian this morning a reporter or a headline talking about the Nullarbor Plain having a similar effect to the Berlin Wall in terms of being a barrier. But just finally, Katie, I do want to wrap up with, I guess, next steps, law reform. Any further changes are they expected as a result of this?
Well, whenever you get noise, some action happens. Yeah, I think definitely we'll see some developments, and we've already seen the caucus statement yesterday, and there'll be some very significant initiatives coming out of that in terms of monitoring enterprise migration agreements and just how that's going to work, we're not quite sure at this stage. Whether it will mean changes for the 457 visa program, I can't see it going down the labour market testing pathway. We've done there, tried that, didn't work even for permanent residents. We discontinued that just over 10 years ago for permanent residents. I do think for those parties which are considering an enterprise migration agreement, and I know the Minister has 3 others on his desk at the moment, that there will be, I'm sure, a very close scrutiny of those, and it's likely that the process of getting to the point of signing may in fact be quite protracted. The documentation, the evidence required, the labour market data, workforce participation data will be significantly more comprehensive. So I'm sure there will be some changes. I think for the general 457 visa program, but that does include EMAs, we will probably see a greater focus on monitoring and compliance. And we've certainly seen last year's budget, $1.7 million identified to spend, you know, increasing the robustness of the ability of the Department of Immigration to monitor compliance of 457 visa sponsors. So I think we'll see that continuing to play. Well,
plenty of action, I'm sure, still to come. We'll leave it there for now, and thank you again for your insights today, Katie.
Thank you, David.
And viewers, thank you for tuning in. We look forward to having your company for next week's Legal Brief.